on the go live button. Hooray, we're finally live on Facebook as well, YouTube, LinkedIn, TikTok, and on Instagram. So excited to be back your way. I hope everyone is doing great. Today we have a very interesting, exciting topic as usual to discuss. So please stick with me. We're going to be going into some good detail about the latest updates concerning US visa approvals at embassies worldwide, and then green card processing within the US. This is what we're going to be discussing today. So get your questions ready and we can get started. Okay, so before we get started, let me make sure that you guys can hear me and see me well. If you can hear me, see me well, type in your in the comment section USA comment section. Just type in USA, or you can drop a flag, the emoji of the US flag, or the flag of the country you're connecting from, whichever one. You can type in USA or a flag. USA. You can type in USA or drop a flag or any other emoji or where you're connecting from, and then I can be sure that you guys can hear me very well, and then we can get started. Okay, wonderful. I see the US flags coming in. Drop in USA, drop in the US flag, drop it wherever you are connecting from. Also, you can drop the flag of that country where you're located. Okay, so as usual, I'm going to be sharing my screen on Facebook, LinkedIn, and YouTube. So if you want to join in that, then you can join through those portals, and then we can review the document that we are discussing today. So today, as I mentioned, we're going to be talking about or going in depth about US visa processing worldwide, as well as green card cases that are being processed within the United States. Obviously, our time is very limited, so we're not going to go into too many dimensions of the discussions. We're just going to hit on some key areas, and then we can, have a fruitful discussion, and then take your questions and then try to answer them all in this video. So as part of the discussion today, we're going to be relying on, or for the discussion today, we are going to be relying on an executive order that was signed by Trump, and that forms the basis of a lot of policy changes and updates in both the issuance of US visas around the world, as well as green card cases in the United States. Some of these policies have already been implemented, others are underway. Some of the federal agents or officers are preparing new regulations, new memos, so that they can effectively implement what's contained in the executive order that we're going to be discussing. Okay, so this executive order is entitled, I cannot see any comments from Facebook, YouTube, LinkedIn. Please, if you're on those platforms and you can hear me and you can see me, please drop an emoji or drop USA so that I can be sure that somebody can hear me and see me. Okay, please do that for us, and then we can quickly proceed. So the executive order is entitled Protecting the United States from Foreign Terrorists and Other National Security and Public Safety Threats. Executive Order 141/61. And I'll start by telling you that a lot of the executive orders have several overlaps. And so you will find some things in this executive order. You will find it in the anti-Semitism executive order. You will find it in the, protecting American people against invasion executive order. There's a lot of overlap. So we'll discuss some of the things that are here primarily, but we will likely overlap into some other executive orders. Okay. So the first thing is that we'll look at the policy and the purpose of this executive order and how it impacts again, or it's going to impact visa issuance, US visa issuance around the world, as well as green card processing within the United States. The first thing is that the US, according to this executive order, is looking to protect its citizens from people who intend to commit what they call terrorist acts, number one, that threaten national security. And then number two, people who hate the ideologies or the ideas of the US. Number three, people who exploit US immigration laws for bad purposes. So the purpose is, first of all, to target these people. Number one, you understand what committing terrorist acts means. You have recently heard about the Palestinian gentleman in Columbian University who is a green card holder and has been detained and is awaiting to hear his deportation or go through his deportation proceedings because he made some comments that are seen as pro Hamas. And Secretary of is it the Secretary of State? I'm not sure which, I believe it's the Secretary of State. Yes, Marco Rubio is stating that he is a threat to national security, and so because of that, his green card is in jeopardy. He's currently in immigration court proceedings, and so we wait to see how that will turn out. Okay, so number one, that's one of the basis of this executive orders. They are going to be targeting such people. You make certain types of comments that don't align with what the government believes should be made, then there is a problem. Obviously, there's legal arguments against this because First Amendment rights and all that. But let's focus on why we're here today. Second is espouse hateful ideology. And so in the issuance of green cards, in the issuance of US visas, they're going to be looking out for people who are stating funny things against the US president, the administration, the culture of the US, or anything US related. Okay, so no hateful ideologies. They're going to be reviewing social medias. They're going to be reviewing certain things or certain statements that you may have made, whether during protests, whether whatever forum you've made those type of statements, those can be used against you if you are applying for a US visa or you are applying for a green card if you are in the United States. And the third one is where you try to exploit US immigration laws for bad purposes. Okay, so here they're likely going to be looking at things like birth tourism, and obviously birth tourism, let me explain again, it's very different from birthright citizenship. People are confusing this all over social media. Birth tourism, you're coming into the United States on a B2 visa for the purpose of having a baby so that your baby will obtain US citizenship. That's the primary purpose of coming while pregnant on a B2 visa, is to obtain US citizenship for your child. And this is known as birth tourism, and it's illegal. The law does not allow. Regulations were updated in 2020, posted in the Federal Register. Regulations do not allow birth tourism. Birthright citizenship, however, is guaranteed under the 14th Amendment. Now, the connection is that birth tourism is possible because of birthright citizenship. Because if the person is a tourist or a visitor, not a citizen of the United States, and they can just come in, once they deliver on US soil, then the baby becomes a US citizen because of the 14th Amendment, right? So things like exploiting immigration laws for bad purposes or malevolent purposes. Birth tourism, President Trump, his administration, Department of State, they've said that they don't agree to birth tourism because people attempt to commoditize US citizenship. And some people who would have otherwise not qualified to obtain US citizenship, they're able to circumvent the process, or they are able to circumvent all the screenings that are done in order to let a person obtain citizenship. And the person just becomes a US citizen, and they're able to process chain migration, because once the baby gets US citizenship, the baby's parents can obtain citizenship once the child turns 21. And so even if the parents would have otherwise not been eligible for US citizenship because of birth tourism, they become US citizens. Okay, so they'll be looking at people who exploit these things. Again, things like diversity visa lottery, which has been a subject of a lot of fraud. They've been very concerned about it. Where there's documentary fraud and relationship fraud specifically. They're going to be focusing on some of these things, or any other, areas where people exploit immigration laws, transactional marriages, business marriages for malevolent purposes. They're going to be looking at all those things. Okay. Now let's move to the second purpose of the policy and the purpose behind this executive order. It says to protect the United States, to protect Americans, the United States must be vigilant during the visa issuance process to ensure that those aliens or non-citizens approved for admission into the US, they don't intend to harm Americans or our national interests. More importantly, the US must identify them before the admission into the admission or entry into the United States, and the United States must ensure that admitted aliens or aliens otherwise already present in the United States, they don't bear hostile attitudes. Okay, so here they are looking at, they're saying that the US must be very vigilant during the visa issuing process, number one. And also, the US is going to try to identify people before they are admitted or allowed to enter the US. And they are also going to be reviewing and scrutinizing people who are already present in the United States. What are they going to be looking out for? Number one, these people must not bear hostile attitudes. If you are non-citizen, you are not an American, you would have to not bear a hostile attitude to the United States in order that you be issued a visa or you be granted a green card. What is a hostile attitude? A hostile attitude, you don't really like the US, you don't really like something about the US, an important part of the US. If you are hostile, that's what people call frenemy, right? It's like, okay, well, you really bear something in your heart against the US or against someone. So a hostile attitude. Sometimes the attitude of the person may not be overt, but it's there. So they are going to be looking at people who bear hostile attitudes to the US. Already one of the directives or the associated directives that have been issued in reliance or based on this executive order is the directive that the USCIS, which is the federal agency based in the United States, they are going to be collecting social media handles of people who apply for some applications, certain applications. They're going to get their social media handles. It's several applications. We'll talk about that in a bit. The other associated action or derivative action based on this purpose of this executive order is that the Department of State also released a memo, a new policy saying that people who are, who work with their home country government or customs officials or airport officials, immigration or foreign government officials, if they allow people to enter the United States illegally, they're going to face very serious consequences. They're going to, they're likely going to ban them or impose some type of restrictions against them. Okay, yes, there's going to be a visa restriction policy that will apply to foreign government officials who facilitate illegal immigration into the United States. So please bear in mind, again, this is based on this executive order because, again, they want to protect the US against invasion and protect against people who will pose as a threat to the United States. Now, some of the affected forms for if you are inside the United States, right? You are inside the United States, you are applying for a green card. The new policy update based on this executive order is that USCIS is going to be likely collecting social media handles to identify verification, national security, enhance identity verification, national security, and public safety so that they'll screen people. And what USCIS has done so far is that they have published or they've issued a 60-day notice and they're seeking public comment on this proposed information collection. So you'll find it, I believe, on the Federal Register that they're seeking comments, and the affected forms that are likely going to collect your social media information if you are in the United States, in order that they'll determine that you are eligible for the immigration benefits. The first application is naturalization. If you're applying for US citizenship through the process of naturalization, then your social media handles are likely going to be collected. Obviously, we need to wait for the public comments process, the comment process or the comment time period to be up, and to see if this will become a final rule and it will be published on the Federal Register, which is where finalized regulations are published, and then they become part of the Code of Federal Regulations of the United States, and that can regulate immigration law. So it's still in the works. However, the first form is naturalization. Okay, they're going to likely going to collect social media identifiers on naturalization forms. Second, asylum. If you are applying for asylum, be ready to give up your social media handles. If it's Sexy Potato 94 or Hit a Hot Mama or whatever it is your name is on social media, and whatever you are posting on there, be aware. If you're applying for asylum, this information is going to be collected. Okay, then the next information, let me take this off the screen, and then we'll go back. Okay, so the next thing is permanent residence. If you're applying for a green card, it's you're actually registering or applying for permanent residency in the United States. That will allow you to work and travel in the United States, or even internationally travel, but obviously you can live and work permanently in the United States. Permanent residence application, that's the green card application 485. And then we have travel documents. So naturalization application, N400, asylum, I believe is 589, then green card 485, then the travel documents, I-131. If you are trying to travel, they're going to take your social media identification as well. Then the next process, or the affected form where they're going to be collecting your social media identification, is a refugee or asylee relative petitions. If you look at the types of applications, these are applications that will grant you some good status. Naturalization, you become a US citizen. Asylum, you get asylee status, and within, after a year of living in the US, you can apply for your green card. Permanent residence, you can get a green card permanently or forever, and you can apply for US citizenship in 5 years or in 3 years, or even sometimes through expedited naturalization. Travel documents, you're here, you're going in and out, right? And they want to be aware of who you are. Are you leaving and coming in to bomb the US or bomb something, right? Like the September 11th terrorist attack. So they want to know who you are. If you're coming in and out of the country, what is your business? What are you trying to do? Then refugee asylee petitions, relative petitions. So, people who are, you have an asylum and then you're applying for your wife or your child. They want to know who these people are, who they are going to be allowing into the United States. Okay, so that's as far as the people who are in the US it goes. They are going to be collecting these informations to enhance security, to make sure you don't bear hostile attitudes towards the US, its culture, its government, its institutions, its founding principles. You don't advocate for or support foreign terrorists that have been designated as a threat to the national security of the United States. Let me see, oh my gosh, what's going on? Oh, okay, I see. No, I'm sorry. Maybe I should, I think my screen is too small. Let me increase the size of the font of, I'm sorry, I should have thought about doing this. Okay, I think this is very good now. All right. Now, when we come to the section 2 of the executive order we're discussing, it says that enhanced vetting and screening across agencies. So they are going to identify resources, people who are seeking admission into the US, already in the US, they are going to be vetted and screened to the maximum degree possible. Maximum degree possible. Again, when we talk about US visas, be ready. There's going to be a lot of scrutiny. There's going to be heightened scrutiny, whether you're applying for a tourist visa, you're based outside the United States, you're based in Ghana, in Kenya, you're based in Sierra Leone, Nigeria, London, Pakistan, Afghanistan. You are going to be vetted and screened to the maximum degree possible. Obviously, once you fill out your DS-160, for example, you're applying for a student visa, DS-160 for your B2 visa, the forms are likely, I suspect that they're likely going to be changed. Even in the United States, several of the forms have already been changed. The wording, even on the 485, the green card application form, a lot of changes. The inadmissibility section, I believe section 9 of the application form, a lot of the admissibility questions, or the questions that will determine if you are inadmissible, meaning you cannot get a green card, they've been reworded differently to see, are you a threat? Like, what groups are you in? Things have changed on the application form. Things are likely to change on the DS-160 if they have not already. The thing about the DS-160 form is that you will typically fill it out online and submit. And so it's not like the 485 or green card application where you can actually, download. Well, I mean, you can actually download your DS-160, but usually you fill it out online and send. But the 485, you can download, fill it out, and then mail a hard copy, so it's easier to kind of keep a copy of the green card. So it's easier to see the differences. But the DS-160 always available online. You cannot really download the form unless, of course, you are done with your application and you want to download a copy, which is fine. So they are going to be vetting and screening to the maximum degree possible. The form questions are likely going to change to elicit certain things. Now, as part of this enhanced screening, guys, again, let me pause by saying that if you haven't followed our pages on social media, please go ahead and follow our pages. And if you can continue to hear me, drop a comment, the US flag, anything, USA, whatever you can drop in the chat box or the comment section, drop it so I can see that you guys can hear me well and good. Share the live video. You don't know who needs our help. Immigration has become a very, very, very serious issue now. It's a matter of life and death. If you even have a family member that's been sending you dollars, they sent you $50 last month, share this video to them, because you don't know what their status is. They could be battling with immigration help, and your sharing of the live video could save them so that you get more money. Because if through you they're able to discover us and they get help, oh my God, you'll be getting a lot more money, right? So wherever you are, share the live video to other people who need assistance. Okay. Now, as part of this executive order, concerning the cases that are being processed inside the United States, what is happening is that we've received information, and we just posted this breaking news across our social media, is that USCIS field offices, well, previously or during Trump era, if you applied for a green card, for instance, through marriage, and you presented a well-documented case that demonstrated eligibility according to the legal standards beyond a preponderance, by a preponderance of the evidence, if you submitted a comprehensive packet or a case that checked boxed what the law requires for a marriage-based green card or for whatever application you're applying for, then chances were very high that your immigration interview could be waived. And so even right at our law firm, we've seen a lot of waived interviews. People would apply for green cards, we submit the case, and the green cards are just issued. They're not called for interviews. Some of our clients were called for interviews, but there were a lot of waived cases. Cases were waived. The couple did not need to appear at a USCIS field office to meet an immigration officer or an adjudications officer. The officer was convinced that the marriage was bona fide and everything looked good, and therefore granted the green card. Now, the information that we're receiving is that USCIS is going to stop the waiver of interviews. Interviews are no longer going to be waived, and the priority for these or for this policy is going to be marriage-based cases. They are going to be scheduling those people for interviews. USCIS has not yet issued any memo or policy memo to that effect. They may, within the coming days or weeks, issue an internal policy memo that will direct USCIS adjudications officers to cease issuing green cards without conducting interviews. We're yet to see that, but this is the information we have received, reliable information we've received across some USCIS field offices. They're going to likely stop. They're going to stop the green card interviews based on marriage or family relationships or whatever. They're going to be required. You're going to be coming in for an interview. And that, I believe, is part of, or it's actually called, I should say called, or gotten out of this executive order where people need to be vetted and screened to the maximum degree possible. How do you vet and screen to the maximum degree possible if you're not meeting the applicant? So again, that's what's going to be happening. A lot of interviews, they're stopping the interview waivers stemming from this executive order. We're likely going to be hearing more about this new policy within the next few days or weeks, okay? Now they're going to determine information needed from any country to adjudicate any visa, admission, or other benefits, and to ascertain for one of its nationals, and to ascertain whether the individual seeking the benefits is who the individual claims to be, and that you're not a security or public safety threat. So they're going to be looking at identity issues. People who you are applying for a visa. Last 3 years, you were born in May 1990. This year, you were born in August 2015. That's a problem. You are one person, you cannot have multiple dates of birth, because then they are unable to identify or ascertain your identity. Let me tell you, two main things are crucial to ascertaining an individual's identity when it comes to US immigration law. Number one, place of birth. Number two, date of birth. Those two things are highly crucial, not even the name. Obviously, the name also plays a factor, but as you guys know, people change their names, right? Somebody can be called John today, and tomorrow they've published, they've gone through the process of a name change, a valid name change in their country, they've gazetted it or whatever they need to do, or they've seen a judge, and now they are known as Smith, their new name. And I've said this before, but imagine what the world would be if people would just wake up and, okay, today I'm feeling Johnish, so I'm called John, and tomorrow I kind of feel Sarah, like Sarahized, so I'm Sarah tomorrow. The world will be it will be a complete chaos. That's why there are rules. If you are called something, you cannot just wake up and decide to change your name without notice to the world. We all live in the world with you, so you got to tell us what your new name is, and it has to go through a process. And so, if you're using changed names, it could be a presumption of fraud unless you're able to rebut it by showing that you went through the proper route and you did a valid name change. But the two crucial things to ascertain your identity: place of birth, date of birth. Okay, there are other things as well, but these things are really crucial. So be careful about those things. If you have these kind of challenges, you want to work it out with an attorney to see how best the information must be handled, because moving forward, this is going to affect visa issuance outside the United States. The various embassies around the United States are going to be looking out for identity issues. Okay. If they're not able to identify who you are, your visa is going to be denied. Nobody's going to be giving you a visa if they can't determine what your date of birth is, where you were born, your name, as well as other important bio data about you. Okay. All right. Now, it goes on to say, again, under section 2.4, it says they're going to vet and screen to the maximum degree possible all aliens or non-citizens who intend to be admitted, enter, or are already inside the United States, particularly those aliens or non-citizens coming from regions or nations with identified security risks. Again, we're also already hearing from reliable sources, news media, the Reuters and some other news media, they've posted that there's likely going to be a potential, or likely going to be a travel ban by the Trump administration, and there's some countries that are likely to be affected. These countries are they've identified that there are security risks, and the countries that they are looking at banning could include the following: Afghanistan, Iraq, Iran, Libya, Palestine or Gaza, Pakistan, Somalia, Sudan, Syria, Yemen. And so we're going to be looking at, and you guys have to be aware, these countries that people are predicting are going to get the travel ban. Remember that the travel ban is usually not is usually focused on non-immigrant visas. Okay, they usually focus on non-immigrant I'm sorry, let me explain that. The restrictions are on immigrant visas, not on non-immigrant visas. So non-immigrant visas, for example, in the previous Trump administration, non-immigrant visas, the travel bans did not impact non-immigrant visas. So non-immigrant visas like F1 visas for students, J1 exchange visitor visas, H1B work visas, those people were not touched by the travel bans, but immigrant visas were affected from people from these countries. There were some of the travel bans that even included Eritrea, Kyrgyzstan, Nigeria, Myanmar, Sudan, and the 2020 Trump travel ban. Okay, and so we're waiting to see what the new list will have, and we're going to inform you guys of which countries have the travel ban. And so that's what's going on here. The countries, people coming from regions or nations with identified security risks. Again, please note that the prior travel ban only affected immigrant visas, not non-immigrant visas. We don't know, however, what this current or potential travel ban is going to include. It could impact both immigrants and non-immigrant visas alike. We are still waiting to see what the memo or what the directive will be once the list or the executive order or the travel advisory, whatever format is going to come in, what is contained in the travel ban. Okay, so yes, they're waiting for the Secretary of State, Secretary of Homeland Security, and Director of National Intelligence. They're going to be submitting the report to identify the countries where they are going to suspend admission of nationals from those countries. Sorry. Okay, and they're also going to identify how many nationals or people from those countries have entered. So if you're already from that country and you've entered into the US, they're going to identify how many, the numbers, and then they may do something with those numbers, review, find out where they are. We don't know yet. Okay. All right. Now, under Section 3 of the policy memo, as part of this executive order, they're going to be evaluating and adjusting all existing regulations, policies, procedures pertaining to each ground of inadmissibility. Okay. So inadmissibility, you guys, we've discussed this several times already. Some people who are inadmissible, it means that they are not allowed to enter the United States. Or if they're already inside the United States, then they are not allowed to get green cards. Okay. Inadmissible is found under Section 212 of the Immigration and Nationality Act. And there are various grounds under which a person can be inadmissible. Number one, you can be inadmissible based on health grounds, which is why if you are outside the United States going through a consular processing, you are required to do medicals. And medicals are usually not applicable to people who are coming in on temporary visas. The COVID-19 vaccine was required. I believe now it's been waived. But if you're coming in on an immigrant visa to become a permanent resident of the US, they gotta make sure you are clean. You can't come into the US and then, be coughing on people and then everybody gets sick because you have something contagious. So they gotta make sure that whatever kind of public, any type of, disease, or should I say disease? Yes, disease that has public health significance and that can be transmitted easily. They want to make sure that you don't have those type of things or things that can harm, like physical, mental disorders or behavioral disorders. So there's a health admissibility application, right? If you're in the United States, is the I-693 form. You will go to a designated civil surgeon and then he will run some tests on you and then fill out an application and then submit it. We submit it to USCIS on your behalf to ensure that you are admissible. If you're in the US, you can get a green card. If you're outside the US coming on an immigrant visa, you can get a visa. Then there's inadmissibility based on criminal grounds, inadmissibility based on multiple criminal convictions, based on one of the most common ones is fraud, misrepresentation, security related grounds, terrorist activities. These are all types of inadmissibilities. And so they're going to make sure that they will adjust all existing regulations so that they can review each ground of inadmissibility listed in statute so that they can ensure safety of the Americans. Okay, let's jump here. Okay, they're going to evaluate all visa programs to ensure that they are not used by foreign nation states or other hostile actors to harm the security, economic, political, cultural, or national interests of the United States. We've recorded several videos on these. They are going to be reviewing all these visa programs, H-1B, visa lottery, all the visa programs to see that they are not being used negatively to harm the United States. And then they'll recommend actions that must be taken. Okay. Again, they're going to evaluate the adequacy of visa programs or programs designed to ensure proper assimilation of lawful immigrants into the United States. Okay, so here, for example, there are refugee programs. When these refugees, come into the United States, those people, they are allowed to do the asylum process and then enter the United States as refugees. And there are programs within their various communities that help them assimilate, for example, into the United States. So they're just going to review programs designed to ensure the proper assimilation of lawful immigrants into the United States. Whatever programs that exist, that's an example I just gave you. Those programs must promote unified American identity and attachment to the Constitution, laws, and founding principles of the United States. Okay, so I think we have to skip to questions. We've already spent over 30 minutes discussing this executive order. I hope you guys have understood what we've discussed. So there's going to be a lot of scrutiny, social media identifiers. We've discussed the travel ban. We've discussed the updating forms and things like that. Let's start taking some questions so that we can see how we can assist some people. We will not be able to answer all questions, but we'll do our best to answer as many as we can within the time frame that we have. Okay. Now let's see. Let me take this off the screen. Let's take this off. And okay, so we have okay, let's see here. Oh, I'm sorry. So Nan J on Instagram says, I want you to assist with filing a DHS trip form. Will you be able to do that with me when I get on a consultation call with you? So I'll tell you what, just yesterday or 2 days ago, I had a consult with someone and she told me about the trouble she was having each time she was coming into the United States. Each time she's entering the United States, she stopped for questioning. She stopped at the port of entry, at the airport. Previously she told me that she would be detained for several hours, and then they'll go over certain things, and then ask her a bunch of questions, and then they'll let her go. In subsequent years, they'll just detain her for some 30 minutes and then just review some things on a computer and then just let her go. So initially, when we started talking, I was like, okay, then we can do a DHS trip filing. A trip filing is a traveler redress inquiry program, and it's actually meant for certain types of difficulties. Let me tell you. So the DHS trip program is a single point of contact for individuals who have had difficulties during travel screenings at transportation hubs such as airports or US borders. Now, if you've had any of these three difficulties, for example, then you can apply for the DHS trip, right? Number one, delayed or denied airline boarding. Each time you're going to board, let's say an airline, Delta, you are delayed, they're checking something, there's a problem. Number two, repeated additional screening. Okay, then number three, denied or delayed entry into the US via airport, border crossing, for example. Then you can apply or file a trip inquiry to find out what's going on. When I spoke with the person, we went some more into how, I went into, okay, how did you acquire your green card? And then we had some very interesting discussions. And then I found out what the problem was and why she was being subjected to repeated secondary inspection. So I told her, okay, the DHS trip is not for you. We found out exactly why you're being subjected to that. And so there's another process that we're doing for her. Okay. So initially when she told me, I had suggested immediately DHS trip, and she's like, oh, what's that? And I explained to her, but then after we did the thorough consultation, we realized that's not what she needs. So the consultation is not a place to fill out things. The consultation is a place where we can go into what's going on and determine whether that's the right thing for you. If you decide to retain us after the consultation, we'll be happy to credit, your consult fee to the fees to, work on this for you. Okay, so all of this to say that's not what you might necessarily need. It might be something. Some people make a lot of assumptions, and a lot of you are, geniuses. Some of you are, you read a lot, and so you might know what you already need. But sometimes you may not need what you think you need. So just set up a time with me, and then I can review what the issue is and see, what we can do to help you. And we're happy to work with you within your budget. Hopefully, we'll try our best to assist you. Okay. All right. I saw some comments that I wanted to read, but I'm not sure why. Let's see if I can go up and up. Let's see. Oh, there you go. Awesome. So I have Pakwesi Hagan who says, hello, Ikea. Hello, Pakwesi. Thank you for joining. Jay says, can we ask questions? Absolutely. Drop your questions. We've started answering questions. So we're here to help. Okay. Now let's go to this person who says, oh my gosh. Sri Lanka J. Wardana says that if someone has a name discrepancy in the DS5501 and DS260, what is the best option? A name discrepancy. So the DS5501 is the diversity visa entry form. That's the form you use to, once the diversity visa lottery form or the diversity visa lottery program opens up in October, you will submit an entry, and that entry that you submit is called the DS5501 form or the DS5501 application. Now, once your entry is selected after the randomized lottery, then you become a selectee for the diversity visa lottery program, a program under which the Department of State will issue about 55,000 green cards every year, or immigrant visas every year, to people around the world from countries with low rates of migration into the United States. If you're selected, then you have to go on and apply for the DS260 if you're outside the United States. The DS260 is a registration for permanent residency, your application to become, or an immigrant visa. You're applying for an immigrant visa. And so if there's a name discrepancy, that is a problem, but it depends on what the discrepancy is. Is it a minor error? When did this discrepancy happen? What is it based on? Is it based on an error, or was it based on an actual name change, or what is it? So you need to set up a time with me and we can review that. It really depends. It really depends. If it's a minor error, usually consular officers may be willing to, just correct it. A lot of the time, some of these discrepancies lead to a presumption of fraud. And if you're not able to properly rebut it, then it becomes a challenge. Okay, so that's why these discrepancies are or could be a problem depending on what it looks like. Okay, so why Hori says if someone in removal proceedings gets approved for a T or U visa by IJ, that's great. If you get approved for a T non-immigrant visa or U non-immigrant visa, then you can have T status or U visa status for sometimes 3 years, and then you can apply for your green card, okay, lawful permanent residency. A T visa is a trafficking visa if you are the victim of labor trafficking. U visa is if you are the victim of a qualifying crime, then you can apply for U non-immigrant status, even if you're out of status. These are all victim-based reliefs available under U.S. immigration law, okay? And so if you are removal proceedings and you are approved for a T non-immigrant visa or U non-immigrant visa, that's wonderful news for you. It means that you'll be good to go. Your proceedings will end, and then you can apply for your green card within the time frame, such as 3 years after being present continuously on the U visa or T visa. So that would be awesome for you. Okay. Now let's see here. Priscilla Napier says, with all that's going on, if you have a case filed and it's pending, are you safe? This is a really, really interesting question. Very good question. Safety. Okay. So it depends. As always, it depends, right? Number one question is, how did you come into the United States? Number two question is, were you in lawful status before you applied for the pending case? Now, if you were in lawful status and you filed a timely, non-frivolous application, then even though your I-94 may have expired, then you are likely in a period of authorized stay by the Attorney General. And so you are out of status, but you are not unlawfully present. You have sort of permission to be present. And so if you're in a period of authorized stay by the Attorney General, then you have receipt notices to show, then you're not unlawfully present, and so you should not ordinarily be subjected to any type of expedited removal or deportation. But again, just having a receipt notice is not a safety valve against being detained or even being deported. But generally, if you have a case filed and it's pending, ICE is not going to be coming after you. They are supposed to prioritize their resources, right? They are approving. And let me tell you guys, another very important or interesting question I've been getting is whether legal migration is still ongoing. It's still ongoing. Even our law firm, we receive countless of approvals every week. Work permits, green cards, US citizenship. Immigrant visas are getting approved despite everything going on. So these things are happening. Cases are getting approved. Immigration is approving cases. Things are working. Because again, think about it. If ICE is going to focus on people who are pending cases, after the case gets approved, then they've just wasted their resources. So they want to prioritize their limited resources. And so they are focusing on people who entered without inspection, have criminal records, who just have, are undocumented with nothing going on and have committed some type of fraud. Those are the cases they are more interested in. Of course, if you're a collateral, You could be picked up if you're found in the wrong company and they are doing a raid and you don't have status and you happen to be there. Then they could detain you before they find out that you have a pending case, and then they could release you. It just depends on so many things. But generally, such people, I would say, are not a target of enforcement. Safety depends on you. Okay, your safety depends on you. It depends on where you go, who you hang out with, what you do. Okay, so you want to be careful of not driving without a license. There's a lot of people who are getting detained because they're driving without license, and you don't have lawful status. These are things that you should not do, especially not find yourself in these type of troubles. Okay, but yeah, that's the answer. And I'll tell you guys that there's a lot more questions still at this point than there are answers. We're still looking at what the patterns of arrests and detentions are. And it's very interesting that CBP has not been very transparent with the numbers. They just actually released information, I believe, yesterday. And the information talked about how many people so far have been arrested by ICE. And prior to this, like the first 50 days, how many people? They said there's been 50 days already since they started their enforcement action. And prior to this, there's not been any live websites where you can go and see that, so far this number of people have been arrested. They were the ones posting it on their social medias, right? And then they were doing it in January, and then they suddenly stopped somewhere in February, and we didn't hear anything. And then suddenly they've come out again with the numbers. So they released a memo, I believe it was yesterday. Yes, just yesterday. DHS, Homeland Security, released a memo, and they talked about ICE arrests in the first 50 days of the Trump administration. And so far, they said they've arrested, they've arrested 32,809 people, first 50 days of Trump. But to put this figure in perspective, in the entire fiscal year 2024, during Biden, ICE enforcement and removal operations, they made 33,242 of these arrests. Okay, so what they're saying is that they beat Biden. Bottom line, they beat Biden, right? So just 50 days, they've arrested 32,809. And for Biden's entire fiscal year, it was just 33,242. So Biden's number is higher by maybe a few hundreds, but that's an entire year versus just their 50 days. So they feel very happy and they're very proud of these numbers. And what they're saying about these numbers, out of the undocumented immigrants that they've arrested in the past 50 days, number one, nearly half of these people were convicted criminals. Okay, so 14,111, they were convicted criminals. And so obviously they're prioritizing convicted criminals. And then 9,980, about a third of the numbers, they have pending criminal charges. Okay. In total, they're saying that they also arrested 1,155 criminal gang members. And those are some of the numbers that ICE released just yesterday in the latest memo. So as you can see, if you have a case filed and it's pending, you are again not really priority for ICE. They're not really going to come after you unless you do something wrong, like you get involved in something or find yourself at the wrong place at the wrong time. The safest place to be is in your home. As always, you have your red cards. You can say, once they knock on your door, you can choose to remain silent, unless, of course, they have an administrative warrant signed by a judge. And that is such a lengthy process. Why would they go to court just to get an administrative a warrant from court? A judicial warrant is a judicial warrant that they need to be able to come into your home. An administrative warrant is the ICE warrant. It does not entitle them to come into your home without your consent. Judicial warrant is the one that allows them to come in if it has your name and all your details. But usually, again, because it's a process and they have to go to court together, they're not going to bother to do that. So usually ICE will not have that judicial warrant. So if you're in your home, then you are safe. But if you are doing other things, you are doing the right thing at the wrong time, or you are doing the wrong thing at the wrong time, then your safety cannot be assured. Okay. Why hurry? Please contact us so that we can assist you. We can review your case and we can assist you. Okay. Um, Dickinson Ejipom Bempa says, can someone travel on to the US on a B1, B2 visa if they have a pending immigrant visa application? The answer is yes. I have the citation right here. We've done several of these cases for some of our clients, and I want to pull it up for you guys. Pending immigrant visa. The answer is yes. It's a little. I mean, it's not even a little. It's a lot more difficult. However, it's possible. Okay, it is possible. Let me see if I'm going to find it here. Um, let me see if I'll find it here. It's possible. The Foreign Affairs Manual, it's the document or the authoritative manual that gives consular officers the rules and the regulations that they need to adjudicate applications. And the Foreign Affairs Manual says that people who have pending visas can actually travel, pending immigrants visas, they can actually travel to the United States. I'm trying to see if I'll be able to pull it up. Let's see. I may have to. Okay. Yeah, they will be able to travel, just that, with a B2 visa, there's a presumption that you have immigrant intent and you have to rebut it in order to be granted that B2 visa. And so if you have a pending immigrant application, that presumption is even more heightened because you're showing that you want to come and live in the US, and now you're saying you want a B2 visa. So they would usually deny that type of application, but the law or the regulations, according to the Foreign Affairs Manual, advises consular officers to approve B2 cases for people who even have pending immigrant visa applications, so long as they can demonstrate that they're eligible for the B2 visa that they're applying for. If you're able to show that you're really just coming in and out despite your pending application, then you'll be granted. But it's very difficult to do that. Okay. And usually what I tell people is that, look, some of these applications, the backlog is insane. So practically speaking, right, let's say your mom is in the United States, she's a US citizen, and you are in Ghana. Mom has filed an F1 visa for you as a married child of a US citizen, or even as an unmarried child of a US citizen, and and you want to come and visit her. If they deny the B2 visa, then they're just telling you that, oh, you can't see your mom, right? And that could cause a lot of family separation. I mean, they don't really care, but the law cannot just say that, oh, because you have something pending, you are not allowed to see your family member. For some people or for some spouses, they apply for their spouse. Sometimes a case will take about 4 years, and mom can be here with the child and dad is in another country. They need a B2 visa to come visit sometime. So the law allows it. It's just very difficult, practically speaking, very, very, very difficult. And a lot of the consular officers will just deny it when they see that you have an immigrant visa petition pending and you're applying for a B2 visa. But you have to make a case for yourself. You have to be able to advocate for yourself. I've recently personally had 2 cases approved on such under such circumstances. So it's very, very possible, but not very common. Okay, Antonio Bana says, can I travel to the United States on the tourist visa, and while I'm in the US file I-130 and also my adjustment of status? I'm an unmarried and my mom is a permanent resident. Okay, so this is a lot to unpack. Number one, you have to obtain visas for the purpose for which you are trying to travel to the United States. and you can only travel on those visas using the required purpose, right, for which the visa was issued. And I've said several times, every alphabet or every letter in the English alphabet has a corresponding US visa, apart from X, Y, and Z. So you have different visas, A, B, C, D. I've actually done a video on this, so you can check that out. I believe it's alphabet soup or something, I can't remember. But A, B, C, D, E, F, G, H, I, J, K, L, all these have corresponding visas. I visa for the media, J visa for cultural exchange program, IJK, K visa, fiancé visa, L visa is an intercompany transfer visa, IJKL, M visa to come and study in the United States, N, O, P, Q, R, all these have visas. Each visa has a purpose. Each visa has a purpose. A tourist visa means just that. It means you're coming in to visit the White House, look at Disneyland, temporary. Tourist visa is a temporary visa. You're coming in, you're leaving. You have a permanent place of abode somewhere else. Now, if you come in on a tourist visa with the intention of applying for an adjustment of status, then you could be deemed to have fraudulent intent and you could have a lot of problems. And so if you're coming in as a tourist, you've got to have the intention and be able to show that you have a return ticket, amongst other things. Some people will come on a tourist visa, they don't even have a return ticket. Right there at the airport, you could fall into trouble. They're coming in on a tourist visa and they've quit their jobs in their home countries, they've sold everything and they've packed everything. They're coming with their certificates, their birth certificates, their school certificates, all their belongings and properties in the world, it's in their bags. That's a problem. That's a major red flag. If CBP finds this out at the airport, you're going to be put right back on the plane to your country through expedited removal after a sworn statement is taken from you. So you have to be careful with the issue of fraudulent intent. If you do, however, come in on a tourist visa, and after you've entered, you determine that, oh, you know what, things have changed and I want to file an adjustment of status, that's fine because you didn't come in with a fraudulent intent of trying to circumvent US immigration laws. Okay, so Antonio, mom is a permanent resident. Yes, mom can file for you for an immigrant visa as the unmarried son of a green card holder under a category called the F2B preference immigrant category. Okay, if you are the spouse of a green card holder, you are F2A, minor child of a green card holder, F2A, F2B, that's your category. Once you get married, unfortunately, you cannot be eligible. You will not be eligible for mom to file for you until mom becomes a US citizen, and then she can file for you under the F3 preference immigrant category as the married son of a US citizen. And so if she does file this for you, just make sure you stay unmarried until you enter the United States on your immigrant visa. Okay. Richmond Blaise says, what do I need to facilitate a visitation from visa from UK to America? I know I'm going off topic with my question. That's okay. Oh, this is a long one. You just need to show 4 things. You're coming into the United States, you're applying for a visa, a B2 visa, tourist visa. 4 things you got to show. Number 1, it's a temporary visit you're coming for. Number 2, the purpose. Okay, so number 1, the duration. It must be temporary B2 visa. Number 2, what's the purpose? For pleasure, not for work or for any other purpose. Number 3, you must demonstrate that you have compelling ties in your country that ties to your country or ties in your country that will compel your return at the end of the visit. And number 4, you have enough money or disposable income to be able to afford the trip. Okay, so the compelling ties is where a lot of people get tripped up. They want to see that you have a job, you have a wife, you've stabilized in that country that you're in, and you will leave the US at the end of the trip. So that's what you need according to law. Now, the types of things you're going to put on the DS-160 is actually what makes or breaks the case, because usually B2 visa, they don't look at the document. So it's the DS-160, the kind of things you're putting on there. We found that that's what actually makes a winning case. So yeah, that's as much as or as far as we can go. Okay, so let's see what other question do we have on Instagram. Amma Very Ghana says, how much is a consultation, please? That depends. Give us a call. Our phone numbers are there, I believe. You can reach us on regular call or on WhatsApp, and you will find you'll be able to talk to somebody at the front desk. Okay. Jennifer, I'm sorry, Jennifer Boating. Oh, I'm sorry, Jennifer Yeboah. Where am I reading all these names from? Jennifer Yeboah says on Instagram, if I don't live with my spouse and we're about to file for green card, do you foresee us having a problem? That's a good question. So I will tell you guys that what the law is looking out for if you apply for a green card, a marriage-based green card. Number one, legal standard is that did you intend to establish life together with your spouse at the time you got married? What was the intention of the relationship? And as part of the application, they're going to be looking at what you've submitted, your documentary evidence, your oral evidence, testimonial evidence, and it's a totality of the circumstances. Again, legal standard is by preponderance of the evidence. And in order to show that it's a genuine marriage, one of the key factors is that you guys live together. Okay, you live together. However, if you don't live together, that in and of itself is not a dispositive factor. It's not enough to get your case denied just because you don't live together. I tell my clients all the time, there are people who have genuine marriages that live in different states in the United States. There are even married couples that live in different countries and on different continents. Their marriage is not fake because they don't live together, right? So it's a matter of presenting your case within the confines of the law. Why do you not live together? Is it a temporary situation? How much are you seeing of each other? How are you communicating? What are the other evidences to demonstrate a bona fide marriage? So no, I don't see a problem just because you don't live together. The problem that I see is where people try to hide that they don't live together, or they lie that they live together when they don't. And then immigration will send an investigator to your home. They do an FDNS visit, a fraud visit, and then they go ask neighbors, or even they go to your home address and there's somebody else there with a man maybe kissing, or like, oh hey, I'm his girlfriend, and yet you filed a marriage petition with someone else. It's like, I'm his girlfriend. Okay, what's your name? And the name the girlfriend gives is not the name on the green card application, meaning the guy, let's say he is a US citizen, he has a girlfriend and he's married to you, and you're filing a green card application. Maybe you're called Samantha. His girlfriend is called Rebecca. USCIS goes to his home, finds the man with Samantha, the girlfriend, and you are called Rebecca on the application saying this man is your husband. I mean, unless you can present information or evidence that he was cheating, then it's going to be very tough, right? So it's not living together. It's not enough to get your case denied. It just depends on the circumstances. If you don't live together, don't pretend and lie that you're living together. It's better to present your case as it is, again, using the law to show why you are eligible. It's not just living together that can determine you have a bona fide marriage, okay? All right, guys, we've run out of time. I hope I've answered as many questions as possible. Don't worry, we're going to be here more often, at least once a week, and we will be attempting to answer many of your questions to help you during this period. If you need our help, please don't hesitate to give us a call, 802-780-0564. Just go into on our social medias, or you can just Google us, AK Poku Law, and you'll find us and you'll be able to call us. We are on all social media platforms, AK Poku Law. You can DM us, or you can find our information usually in the bio section, and you'll be able to set up a time to speak with me, and I'll be very happy to meet you and assist you with your case. All right, guys, it's been a pleasure having you on this session. And, just don't forget, if you haven't followed our page, follow our page, like our page, drop a comment if you found this question, this session insightful. Please, if you need one-on-one personalized help, give us a call. That's when myself and our other attorney can go into your case. Legal team will review it and we'll do a detailed consultations. Everybody talks about how amazing our consultations are. Before they come, some of them will cry and say, "Oh, the consultation fee, why is it X amount?" But it's by the time they are done, they are so happy. They are so happy. They are so happy because they got so much value out of the consultation. It's a great session. So I encourage you, you need one-on-one help, give us a call and we'll be happy to give your case the attention that it deserves. Okay. Oh, thank you guys so much. Thank you. Thank you, everybody. I appreciate your joining. So I'll see you on our next live session. Okay. Take care and bye-bye. Bye. Thank you for joining.